Good day, my fellow freedom lovers and sovereign thinkers. This is LL3's latest podcast. My name is Craig, and it's early morning, January 30th, 2014. I am podcasting in the beautiful swampy mangroves of South Florida. And today I'm going to be narrating the topic and discussing it as well. It's entitled HB 733, which is Florida House Bill 733, Federal Regulation of Firearms. This was a general bill that was authored by House Legislator Dane Eagle, who was a Republican from District 77 in Florida, and plus he had a couple of co-sponsors, Mayfield, O'Toole, and Smith. And it says here on the Federal Regulation of Firearms, designated act as Second Amendment Preservation Act, provides legislative findings, prohibited specific actions to enforce certain federal regulations of firearms and ammunition, provides for loss of position or office of agent or employee of state who violates prohibition. This was filed a few days ago on Monday, January 27th of this year at 12:45 p.m. Eastern Time. So I'm going to be reading the original bill text, and it'll be under statutes 790.339. That's referenced by this bill. So I'm going to click it on right here, and come on. Oops, got right there. My mistake. Okay, here we go. HB 733. That's for 2014. A bill to be entitled an act relating to federal regulation of firearms, providing a short title, providing legislative findings, creating statute 790.339, prohibiting specified actions to enforce certain federal regulations of firearms and ammunition, providing for loss of position or office of an agent or employee of the state who violates the prohibition, providing a directive to the Division of Law, Revision, and Information, providing an effective date. Be enacted by the legislator of the state of Florida. Section 1. This act may be cited as a Second Amendment Preservation Act. Section 2. This act shall have no effect on the right to keep and bear arms pursuant to the Florida Constitution and defined by state law. Section 3. The legislator finds that the Second Amendment to the United States Constitution, as it reads, a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The legislator finds the enforcement of firearms and ammunition regulations remains a power reserved to the state of Florida and the people therein. Section 4, Section 790.339 of Florida statutes is created to read 790.339 Federal infringement of the Second Amendment rights prohibited. 1. Notwithstanding any provision of law, the state of Florida and its agencies, political subdivisions, constitutional officers, officials of its agencies and subdivisions, and their successors, or an employee of such an agency acting in his or her official capacity, or corporation or person providing services to or on behalf of the state shall not, concerning any act, law, order, rule, or regulation, whatever past, present, or future, of the federal government relating to a personal firearm or firearm accessory within this state that applies to a personal firearm or firearm accessory based on the design, features, or characteristics of the firearm or accessory. Subsection A. Enforce any such federal act, law, order, rule, or regulation. Subsection B. Provide material to support, participate with, or assist in any form any federal agency or employee engaged in the enforcement of any such federal act, law, order, rule, or regulation, or any investigation pursuant to the reinforcement of any such federal act, law, order, rule, or regulation. Subsection C, use any state's assets, state's fines, or funds allocated by the state to local entities on or after the effective date of this act, the whole or in part, to engage in any activity that aids a federal agency, federal agent, or corporation providing services to the federal government in the enforcement of any such federal law, act, law, order, rule, or regulation, or any investigation pursuant to the enforcement of any such federal act, law, order, rule, or regulation, as these federal laws shall be not be recognized by the state or specifically rejected by the state and shall be of no effect in this state. An agent or employee of the state who knowingly violates subsection 1 shall, subsection 2, excuse me. Any agent or employee of the state who knowingly violates subsection 1 shall be deemed to have resigned a commission from the state that he or she may possess, and his or her position or office shall be deemed vacant. Section 5. The Division of Law Revision and Information is directed to replace the phrase "the effective date of this act," whatever it occurs in this act, with the date this act takes effect. Section 6. This act shall take effect upon becoming a law. Yeah, it's I have to say it's a very good start. It's not perfect, but it is an oracle on what we can do to make Florida more constitutional friendly, I would say. Because I know here when it says on section 2 of this document, it does not affect on the right to keep bear arms pursuant to the Florida Constitution and defined by state law. Because there are some regulations, but I'll get to that in a moment. And like I said, it is a very good start. And I do commend Dan Eagle for supporting it, and everyone that was involved, including the 10th Amendment Center, Florida 10th Amendment Center, were really pushing this because no other states, I believe Kansas passed it, and some other states are still having this on the floor as well, which is incredibly great. And here's the 10th Amendment cause, and you can read, I could just read this to you. Amendment 10, the power not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Okay? And let's hit Florida Constitution, Article 1, which is entitled Declaration of Rights. And we'll hit Section 2, Basic Rights in the States. All natural persons, female and male alike, are equal before the law and have inalienable rights, among which are the right to enjoy and defend life, liberty, and to pursue happiness, to be rewarded for the industry, and to require, possess, and protect property, except for the ownership, inheritance, disposition, and possession of real property by aliens ineligible for citizenship may be regulated or prohibited by law. No person shall be deprived of any right because of race, religion, national origin, or physical disability. Well, like I said, on this, it's prima facie just cause on a lot of federal state laws. And let's just hit Section 8, which needs to get work to be done. When it says here, it says right to bear arms, subsection A, the right to keep and bear arms in defense of themselves and the lawful authority of the state shall not be infringed, except that the matter of bearing arms may be regulated by law. It's like a flip-flop there, okay, a subsection A. And we'll hit subsection B. There should be a mandatory period for 3 days, excluding weekends and legal holidays, between purchase and delivery at a retail of any handgun. For the purpose of this section, purchase means the transfer of money or other valuable consideration to the retailer, and the handgun means a firearm capable of being carried and used by one hand, such as a pistol or revolver. Holders of a concealed weapons permit, as prescribed in Florida law, shall not be subject to the provisions of this paragraph. See, another compromise there is more of a privilege, because a concealed weapon permit, like I addressed in my past episodes, it's a privilege because they want your fingerprints and all that for a concealed weapons permit. So it's not considered an actual right to bear arm to carry on itself, but a privilege, which is like I still say that sacrilege in respect. And here, subsection C, the legislators shall enact legislation implementing subsection B of the section effective no later than December 31st, 1991, which shall provide that anyone violating the provisions of subsection B shall be guilty of a felony. Subsection D, this restriction shall not apply or trade of another handgun. See, subsection C, in my perspective, it's more of a victimless crime law. Who is the injured party? You know what I say? No victim, no crime. If something like this happens in court, you got a particular case, you're a juror, you can still say not guilty. Remember that, jury notification. You're the most powerful person in the courtroom, not the judge. And we can just hit subsection 9. Okay, is which just contradicts, which does go, double standards here. Due process, no person shall be deprived of life, liberty, or property without due process of law, or shall be put in jeopardy for the same offense, or be compelled in a criminal matter be witness against oneself. So you have to have due process of law. All right. So of course, subsection 12, search and seizures. I don't have to really explain. I'll just do the first sentence. The right of the people to be secured in their persons, houses, papers, and effects, which is property, against unreasonable search and seizures, and against the unreasonable interpretation of private communication by any means shall not be violated. The rest of it is very coexisting with our Fourth Amendment United States Constitution. So I just have to do a little quick paraphrase on that. And with the whole purging scene, waiting periods and all that, I consider that to be a violation of your right to privacy. Every natural right of privacy. Every natural person has a right to be left alone and free from governmental intrusion into the person's private life, except as otherwise provided herein. Well, I'm sorry to hear about that. So this section shall not be construed to the limit to the public's rights of access to public records and meetings as provided by law. So you know what I say, and a peaceable, free-willing individual is violates the right to privacy and some of those so-called regulations. And we can hit another area which needs to be dissolved, because I can say this before I keep going about subsection B and C, the 3-day waiting period. I voted against that. I was like 19 years old. I voted no on that amendment, and I still don't regret it, and I still stand it till today. And let's go hit here. Article 7, Section 5B. Local option. And it says here, each county shall have the authority to require a criminal history records check and to a 3 to 5 day waiting period, excluding weekends and legal holidays in connection with the sale of any firearms occurring within such county. For purposes of the subsection, the term sale means a transfer of money or other valuable consideration for any firearm with any part of the transaction is conducted on property to which the public has the right of access. Holders of concealed weapons permits, as prescribed by general law, should not be subject to the provisions of the subsection when purchasing a firearm. Again, a privilege. Waiting periods. I know some of the counties like Dade, Broward, Palm Beach, they have 5-day waiting periods for all firearms, okay? For all firearms, which is a sham. I voted against that as well in 1998, and I still stick by those principles today. That needs to be repealed as well. So on those areas within our state constitution, we have to honor that as well, because remember, if you look at Article 6 of our U.S. Constitution, and second sentence, if I believe it's the second sentence, second paragraph. Yeah, second clause.